Welcome, Mr. Ehtasham Sahib. Yeah, a very warm good morning. Well, I formally welcome you. Today, I propose to discuss yes, what correction issues at the Sham Sahib. Welcome, ma'am, and good morning.
Good morning, sir. How are you?
Fine, ma'am. Fine. How are you?
I'm good as well.
Yeah. Well, today we were deliberating, and some of the issues I was supposed to take up today. Could you please remind me?
Sorry, sir.
We were deliberating certain important issues. So, can you remind me exactly where I have left yesterday?
I'm sorry, so it's taking me time. I don't know why I'm not remembering. We were talking about statelessness. We talked about Myanmar issue and Indian situation. Vikas discussed it.
Yeah.
Yeah.
Well, Ehtasham Sahib, let everybody come, and thereafter I would also be taking up. Uh, I assure you that I will not leave any issue, whatever the issues have been raised in the online classes. Every issue would be treated well, addressed well. Today I propose to deliberate the principle of refugee and migrants protection under the Global Compact on Refugees and Migration. We would also be cajoling certain important guarantees, safety valves, protection mechanisms, and other important dimensions which are likely to be invoked, have been invoked in the past from international human rights law framework, international humanitarian law framework, international criminal law framework, international constitutional law framework, and the role of international institutions in the protection of refugees and migrants. We have to undertake and consult certain important guarantees which have been provided under 1984 UN Convention Against Torture, 1990 UN Convention on the Protection of Rights of All Migrant Workers, again 1990 UN Convention on the Protection of Rights of All Migrant Workers and members of their families, national legislations, whatever the legislations over the years have been passed by the various jurisdictions, national jurisdictions I am talking of, and in one single word, I should say non-binding instruments at global level. It may be the soft laws, it may be the hard laws, and UN Office for the Coordination of Humanitarian Affairs guiding principles on internal displacement. This should also be taken up once again. Then the UNHCR Handbook for the Protection of Internally Displaced Persons. Then UNHCR Text 2, particularly the preface, forward, and introduction, along with Chapter 1, whereunder the safeguarding human security has been provided. And thereafter, we are going to take up 2016 New York Declaration for Refugees and Migrants and 2018 UN Global Compacts on Refugees and Migrants. Under these instruments, we are supposed to understand and address certain specific questions as well. And before I proceed further, at a later stage, I would also be taking up the idea of climate refugees that still remains to be addressed. Because we have also co-authored a book on climate refugees in South Asia. So I want to give a detailed treatment to this new concept of climate refugees. Intersectionalities of the climate migration and climate refugees. There are many other scholars who have been addressing this kind of a migration and human displacement as environmental refugees. So we would be taking up at a separate stage for a detailed treatment so far this particular dimension of refugee protection is concerned. But in this particular engagement, there are certain important questions, there are certain important deliberations, discussions, and dimensions. Suppose there is one question, are people illegal? Is there any possibility of people being illegal? Is it correct to call people illegal? Because it has become a fashion, whatever we have been witnessing of late, it has become a fashion, particularly on the part of the national governments, to call people illegal, particularly those people who are fleeing persecution territories, who are fleeing hostile environments, people who are taking a flight or suffering from forced migration dynamics. They are generally addressed whenever they cross international borders and knock the doors in their neighborhoods as well as in other territories. Generally, national governments describe them, depict them as illegal. So here lies one of the most important questions: are people illegal? What are the basic human rights of these people? What are the basic human rights of refugees outside the mandate of UNHCR as well as outside the 1951 UN Convention relating to the status of refugees? Is there any possibility to protect refugees without the mandate or without the application or outside the application of Refugee Convention? How can the rights of refugees be protected under international human rights law framework? What is refugee status solution to? Where the line between state sovereignty and individual protection should be drawn? What is the coterminous relationship between sovereignty, state sovereignty, and individual protection? We have already crossed the teachings of Rousseau, Voltaire. These were the thinkers and many other thinkers who came out with the idea of individual rights. Rousseau has rightly talked of in his social contract thesis that it is the individualism, it is the individual rights, it is the rights of the citizens, it is the rights of the subjects which should be given priority as well as supremacy over the monarchy. So in such a situation, because the literature is instances are, we are having enough instances, replete instances where we should try to understand these are the individual rights, collective rights. And that is why the journey that has been started by these thinkers, and they have provided some kind of a alternative view so far the rights of individuals are concerned, which ultimately ensued even the French Revolution. Because of the these kinds of thinkers, even the Louis 16th and his father Louis 15th and other important members of the royal family were subjected to rigorous kinds of punishments. So you can very well understand that history has given us a lot of light in understanding the rights of individuals, and refugees are also individuals. Refugees also constitute groups. Refugees are also form the part of decision making. Today what we have been witnessing, that the refugees are generally not consulted whenever the decisions are taken for their integration, for their resettlement, for their repatriation. And that has presented a very, very challenging situation because refugees' voices are not heard. The voices of refugees constitute a very, very important stakeholder in entire decision-making process. This has given another set of what you call of questions. The questions like, is the notion of a refugee dependent on and defined by the existence of sovereign nation states? What is the role of international organizations, non-governmental organizations in refugee protection, and how have they transformed the understanding and application of the idea of protection? Is a successful refugee protection regime reliant on responsibility sharing by states? If so, how is responsibility sharing and state accountability to be improved or achieved? What are the basic human rights? What are the basic human rights of the refugees beyond the Refugee Convention? How can the rights of refugees be protected under international humanitarian law framework? How to draw some kind of a line and how to define a migrant? What are the vulnerabilities in large refugee movements? What is the legal framework of human rights and protection for all migrants? And what are the draft principles and practical guidance on the human rights and protection of migrants, particularly in situations of irregular migration or vulnerable situations and in mixed and large migration movements or large influx of people in the form of what we call of human mobility or migration. So these are some of the important questions that must be what we call understood and addressed under the New York Declaration as well as global compacts on refugees and migrants. But before I proceed further from here, it would be in the fitness of things that when we are talking of refugee protection, and particularly under two important frameworks, that is international human rights law framework and international humanitarian law framework, this reminds me of a very, very important dimension. And this is a dimension which is available in the TADI case. The appeals chamber of the ICTY in the TADI case is specified an armed conflict to exist whenever there is a resort to armed force between states or protracted armed violence between government authorities and organized armed groups or between such groups within a state. With regard to the distinction between international and non-international armed conflict, ICTY has also found that the certain norms of international armed conflict are applicable to non-international armed conflict based on customary international law. Because whatever may be the nature of the armed conflict, my dear friends, they generally produced civilian population who is subsequently addressed as war refugees. So in this reality has been identified in this particular decision, and that is a decision of 1995, which is popularly known as the prosecutor versus Static. Therefore, it has become incumbent upon us that we should, under all circumstances, try to understand that there are protection mechanisms which are available for refugees, for migrants, for defenseless people who are on the move. It is a wrong kind of an argument if any nation state is making that our nation state is not a party to 1951 convention relating to the status of refugees along with its additional protocol of 1967. It's a highly fallacious argument. It shows the intellectual bankruptcy of legal mind in any geopolitical entity. This kind of a plea cannot be taken and should not be entertained by the judicial minds or the minds in judicial robes. Because this particular engagement becomes very, very important, because a considerable amount of devotion would be there which is taking into consideration that we have to protect refugees without applying 1951 Convention or its additional protocol of 1967. Protections to refugees were available in the absence of or prior to 1951. Refugees were protected, protections were available to them under the national constitutions, under customary laws, under traditional what you call understandings, under the laws of common humanity. Protections have always been contemplated for the people who are fleeing persecution, hostile environment, generalized violence, massive violations of human rights, and other forms of discriminations which are or which have been designated as highly hostile to the human sustainability. Therefore, the issue of human rights is frequently discussed in international discourse, among world leaders, and in international media. At any given time, my dear friends, there are world conferences on human rights, speeches from presidents and popes alike about the need for tolerance and respect for human rights, and media outlets airing one program after another on the poverty and poor living conditions around the world. And among the most notable channel, if you are really interested, my dear friends, to understand the different what you call issues, then the documentaries which are generally aired by the DW German television, the English German television, should also be consulted. Because whether it is the world poverty, whether it is climate change, whether it is the refugee issues, whether it is the irregular migration, or climate change induced human mobility, then some of the important documentaries aired by DW English channel becomes very, very germane to the ongoing deliberations. Although what is exactly meant by human rights remains controversial and ambiguous. It is, my dear friends, it is increasingly clear that there is some international concept of human rights, and we cannot run away from it. The whole previous semester, one paper in the previous semester was exclusively devoted to the understanding of international human rights law framework. Therefore, in societies where citizens are by and large free to participate in the political process and express opposition to their government, where they do not simply disappear in the blink of an eye and are generally free from hunger and poverty, human rights may never be a chief consideration or concern. Unfortunately, this only describes the situation of a minority of the world population. The acknowledgement of human rights as an issue by the international community has led to the creation of a vast network of laws, treaties, and international organizations. Most states today recognize some limits to their sovereignty, and at least ostensibly, my dear friends, agrees to treaties and covenants designed to protect those very rights, which are known as fundamental human rights and freedoms. Prior to the Second World War, such a concept would have been deemed untenable, as state sovereignty remained the norm of international relations. States were the final arbiter in the treatment of their citizens, and other states should refrain from intervening in their affairs. Suppose the Holocaust and atrocities associated with Nazi regime served as a catalyst for the human rights movement, propelling the issue into the international arena. After the Nazis attempted to systematically eliminate the Jewish population from Europe, as well as targeting gypsies, the handicapped, elderly, and homosexuals, the world's response was one of the horror. It was the extermination of over 6 million people by the Nazi regime that created the political will to mount the first true challenge to the idea of sovereignty with respect to human rights. International discourse on the importance of human rights has continually increased, my dear friends, since the end of the Second World War. But many states continue to violate a wide range of rights. And this is something which has become the fashion, which has become the part of the behavior of states, nation states. It got embedded further in the DNA of state behaviors. Therefore, some of the worst human rights violations have occurred in modern times. The atrocities committed by the Khmer Rouge in Cambodia, the ethnic cleansing in the former Yugoslavia, the slaughter in Rwanda, the genocide in the Darfur region of Sudan, or United Sudan, I should say, because the Sudan recently has already been divided into Sudan and South Sudan. Persecution of Hindus, Sikh, Shias, Ahmadiyas, Chakmas, and Rohingyas in Afghanistan, Pakistan, Bangladesh, and Myanmar, and perennial pogrom of Muslims and Christians everywhere in the world. Food insecurity, lack of clean water, and lack of basic health care services continue to be the everyday realities for much of the world. Further, my dear friends, that slavery, again, with its new manifestation, happens to be on the rise today. In Eastern Europe and South Asia, women are trafficked as sex slaves. In the Democratic Republic of Congo, children are being forced to fight in wars. And in most of the SAARC region, particularly in India and Nepal, children are being forced to work as child labor or in roadside eateries or in street. And street shops, particularly the sweet shops for subsistence wages instead of attending school. For many people, my dear friends, the lack of human rights is a daily reality, while citizens in parts of the world are experiencing greater respect for human rights. The majority have yet to realize and enjoy the full spectrum of human rights. The disjuncture between the discourse on human rights and the realization of human rights is one of the important paradoxes of the study of human rights in the context of refugee protection. Because it is axiomatic, it is evident from our deliberations, whatever we have started in the last semester, the concept of human right is not new. Many states and communities have been established on this particular idea, which is having a universal persons, universal application, universal realization, and at the same time the individual members have certain inherent rights which must be respected by those who have become the part of the governance establishments. Idea of human rights may be based on religion or religious, political, moral, or social grounds. And it is a mistake to assume that it owes its origin to any one particular doctrine or theory of governance or theory of government. Rather, human rights, my dear friends, are best understood as a common and unifying expression of all people's deepest aspirations to live freely and securely in a just and peaceful world. Human rights, as a natural response to the violence repression, acute poverty, and insecurity that plague the world we live in. And this has generated and given human rights a unique character which is known as a cosmopolitan character. And the best example of the cosmopolitan character of a of the idea of human rights is basically we find in a one particular document, or this particular document as a whole should be regarded as an idea of what we call of human rights, and that is Universal Declaration of Human Rights, and it is equally available, my dear friends, to refugee protection as well. If you take an example of the mixed movements or large movements of of migrants and refugees, then the core element which we identify in these movements is basically an element of vulnerability. And within the context of many migration movements, my dear friends, a diverse group of people move together and often share the same risk of human rights violations. That really makes it vulnerable. Many people on the move today, whether Mexicans, Venezuelans, or many other groups from the Latin American nation states in the contemporary world, they happen to be on the move today but fall outside established legal categories or fall in and out of some of the categories, but are nonetheless in need of specific protection interventions. All of you are well acquainted what has been the response of the Trump administration, how Trump administration has treated these Mexicans and Venezuelans when they were marching towards American borders, when they faced a wall along the Mexican and US border. People generally compelled to move in large scale, irregular and precarious movements are particularly at the risk of what we call of harm. Migrants can be at risk of human rights violations due to the conditions they face in countries of origins, countries of persecution, countries of their nationalities, which compel them to move, and to which I'm sorry. And particularly to those they do not face the viable and normal situations in their country of origins, and in near future they don't see any kind of a possibility of returning to their country of persecution or country of their origin. Migration, at the same time, migrants can be once again be at the risk of human rights violations as a result of circumstances that they face en route, in transition, in migration, in destination. The structural context, therefore, my dear friends, are diverse, and inherent vulnerabilities can lead to intersectional risk, particularly, for example, children. They are going to be the biggest, and they have been the biggest casualty in these kinds of large movements. Journeys, because the journeys are long, dangerous, and often multi-directional, and some may never reach their intended destination. And sometimes it has also been seen whenever the refugees take any kind of a boat, they are generally addressed because of their taking boat as boat people. They face inundation. They generally confront capsizing, and sometimes their boats are left unattended and they are never salvaged. So in this context, we can say that the risk faced by these kinds of human mobility at the destination, or at the sea, or even in land routes, or in transition, innumerable hardships are there. Innumerable risks are, there. But here lies another important question. Why do people move? People move, my dear friends, there are multiple, reasons. And I am of the view that you should not confine whatever the issues I am going to adumbrate, whatever the issues I am going to share with all of you. You can supplement those very issues. You may have all your disagreements with this entire what you call, katana of issues or cluster of issues. Like people move because of livelihoods. You may call them because of the economic reasons, because of the better opportunity to eke out a dignified living in different what you call lands. People move because of food, because of water, because of insecurity. Republic of Congo, Republic of Yemen, and many other nation states are an example. Because of water, because of food, people are moving and living their country of origin, like Yemen. Because of poverty, people are fleeing. Because of non-availability of access to health or education and other important requirements for a sustainable human existence, people are moving and fleeing. Because of generalized violence, because of exploitation, because of racial discriminations, because of persecution on certain important grounds which are beyond the understanding of the general population, because of the civil war, insurgency, conflicts, violence, war conflict of a non-international character, as well as the armed conflict of a international character, because of climate change, natural disasters, family reunification, and many other important considerations may also be there. People happen to be on move, and that is why they are fleeing. Therefore, if you take into account that migrants who move out of necessity rather than free choices are often unable to formulate exist strategies when migration doesn't go to plan. That is why lot of barriers have been what we call created, barriers to migration and lack of self what we call, or safe pathways. Suppose whenever the people move, even the national governments do not cooperate. International community is not at all bothered how these international migrations or the migrants who are crossing international borders, how should they be treated. We do not have any kind of a mechanisms, particularly the human rights oriented mechanisms or human rights backed mechanisms. They are not in place, like punitive border control measures they generally confront. Dangerous interception practices are resorted by the border checks, armed forces, or the law enforcement agencies and law enforcement personnel posted at the border checks. Then we have also been witnessing the criminalization of the irregular migration. That is another important what we call danger. Mandatory detention policies are being resorted, and that is why these mandatory detention policies have also created another set of what we call violations of human rights, because many nation states have created detention centers. Many detention centers have been created by the Congress government in India. As many as more than 5 detention centers were created, established by the Congress led government under various prime ministers of Indian National Congress. And if you recall yesterday's deliberations, even the Supreme Court of India has also used the word not detention center instead of using detention center terminology, the Supreme Court of India has used holding centers. So whatever may be the nomenclature, but the result is the same. So you can very well understand, because whenever we are going through a judgment, whenever we are studying a decision of a judicial nature, when we are studying any kind of a judicial order, then each and every word becomes very, very important, because we have to apply our legal mind to the judicial mind. There are other important barriers like unsustainable written policies, as we have been witnessing in case of Myanmar. Recently, even the government of Bangladesh has also initiated the repatriation program of the Rohingya refugees back to their country of origin, and that is Myanmar. Then the government of Bangladesh did not get any kind of a viable solution on the part of the government, civilian government of Myanmar. Now it is being run by a military junta. So we cannot expect the full-fledged what we call satisfaction of all the requirements as per the IHL, International Human Rights Law framework, as well as International Humanitarian Law framework, where the common Article 3, so far the International Humanitarian Law is concerned, the common Article 3, which is of a customary international law nature, become relevant and central in any kind of a peaceful talk or peaceful accommodation and rehabilitation and resettlement of these refugees. Then we are also witnessing another important barrier, and that is the violence and exploitation. So these are some of the important what we call impediments, hiatuses, which have been created by the nation states instead of addressing the problem of refugees under international human rights law framework, as well as under international humanitarian law, international constitutional law. Then we are also having another set of not another set of framework, but if you take into account a multitude of frameworks, then we are able to solve refugee problems. Forget about international refugee law. We are also having, as I have already submitted, international humanitarian law, international human rights law, law of the seas, UN Convention on Transnational Organized Crimes, backed by additional what we call protocols, then UN Convention on Statelessness, then again International Convention on the Protection of Rights of All Migrants workers, and international labor law conventions, international maritime law conventions, as well as some other important major constitutional provisions in major national jurisdictions. So we are having all kinds of protection mechanisms. But what remains to be studied is, my dear friends, that there are certain important principles and practical guidance. And we try to evolve, we try to cajole, we try to cull all these practical guidance in the form of principles and guidances from these important instruments under the broadly of these frameworks, or under the multitude of these frameworks. Making this kind of a plea before the judicial authority or before the Honorable Supreme Court of India, if the government of India is contending that it is not a party to 1951 convention, it is a flawed argument, fallacious arguments, untenable argument, intangible argument, and ostensible argument. Ostensible in the sense that they are creating some kind of a ground which it does not have, or which cannot be tested on the judicial reasoning, which cannot be measured at the anvil of judicial scrutiny. It is an argument which cannot withstand the judicial scrutiny. Can we have this kind of an argument? You have already studied in your comparative constitutional law paper that how international treaties, how international obligations are generally respected within the municipal legal system. Whether you are a party or not, whether we are a party or not to these international obligations. Government of India has signed 1984 UN Convention Against Torture, but it has not ratified as of now, but it has signed. This particular Article 3 of Torture Convention has not been invoked. And moreover, nobody has talked of as many as 4 important human rights lawyers appeared on behalf of Mr. Salimullah before this bench headed by the Chief Justice of India. They haven't contended. They haven't contended the application and invocation of customary international law. In this particular case, my dear friends, with due regard and due apology, it appeared prima facie that the arguments were not submitted before a judicial, establishment, rather an administrative establishment was listening all the arguments. I apologize for my, arguments, my submissions. But I wanted to witness a greater amount of a sort of unprecedented sort of jurisprudence should have been produced by the Supreme Court of India on these issues. A jurisprudence that would have attracted all the judicial minds available at global level. But it was an opportunity that has been missed. It has become a redundant argument, an obsolete argument, an archaic argument in the contemporary circumstances. If the national governments and the top law officers of the governments are taking this kind of approach, that our government is not a party to such and such human rights arrangement, because 1951 convention relating to the status of refugees, strictly speaking, is not only a refugee convention, but at the same time, more than a refugee convention, it is an international human rights law framework, or one of the constituents of the international human rights law framework. I am talking of a better light should have been given by the Honorable Supreme Court of India, instead of a grammatically oriented interpretation of some of the important arguments. Only the governmental arguments have been recreated, recrafted, and redrafted in the interlocutory order or in the entering order of the Honorable Supreme Court of India. Nothing new has been found. And therefore, we have to make a case for the principles and practical guidance. Because when we are talking of the international legal protection framework that exists, that specifically protects the rights of all the migrants and refugees. In other words, let me put it like this, that a more precise understanding of the human rights standards for migrants, particularly in large movements, as well as of how states and other important stakeholders can operationalize these international human rights standards in practice, is also lacking. We have to create. When I'm using the word we the people of the world I'm talking of, we the people of South Asia, we have to create a human rights culture, a human rights fundamental freedoms culture, a human rights fundamental human duties culture. Everything cannot be left on the governance institutions. We as the people, we as the citizens, we as the stakeholders must also come out to respect in our daily life that very social contract which we have submitted. And that social contract, if I am allowed to invoke Rousseau's terminology of the social contract, then in the modern day circumstances, that social contract is the constitution of each and every geopolitical entity, wherefrom we should evolve fundamental human freedoms. We should also be able to understand our limitations. Because when we are talking of rights, we are basically talking of limitations. We cannot have unfettered freedoms. We have to respect each other's freedoms as well. And each other freedoms also includes the rights as well as the freedoms of the national governments. We have to create some kind of a balance. Then only we can survive and create dignified human societies, or the human societies wedded with human dignity, humanity, rule of law, due process of law, and fundamental human freedoms. Therefore, my dear friends, need for particular understanding, particularly of the protection gaps experienced by the migrants who will not benefit from refugee protection, but nonetheless are not moving voluntarily and on in a protected manner, must also be attended. When we are talking of the principles and practical guidance on human rights and protection of migrants in vulnerable situations, then without any kind of a prejudice to the specific rights of refugees, as per their definition, as per their explanation, and whatever the explanation has been provided under 1951 UN Convention relating to the status of refugees with its additional protocol of 1967 and those of other specific groups of non-nationals. International human rights law and standards and related bodies of law must also be invoked to provide some kind of practical guidance, and we should incorporate those fundamental principles which we have gathered in the form of MDGs, SDGs, as well as the fundamental principles which we have identified in the Universal Declaration of Human Rights. These practical guidance, I mean the principles of the Universal Declaration of Human Rights, my dear friends, have been designed to states, to assist states and other important stakeholders to develop, strengthen, implement, and monitor measures to protect migrants in vulnerable situations. An effort of the global migration group on human rights and gender equality and other important stakeholders, particularly the International Organization for Migration, United Nations High Commissioner for Refugees, and other important international human rights groups, and their good practices must also be taken into consideration. We have to undertake. Recently, I was going through a report that has been provided by the Global Migration Group, GMG. And this working group has come out with a draft set of 15 principles, which have been derived from international human rights law framework, as well as other important standards which have been set in other branches of international law. Each principle of this particular group, each principle is followed by a set of related practical intervention to give effect to the legal obligations inherent in the principle and thereby address protection gaps. Because whenever the judicial contentions have been there, whenever the judicial litigation has been there before the national judicial tribunals, highest judicial establishments in a geopolitical entity, or any quasi-judicial forum instituted at a global level, international level, or at a regional level or local level, gaps have always been identified. But if we take into account the fundamental principles as well as the practical guidance that has been evolved by this global migration group, GMG, and take into account the 15-point program that has been offered by this particular group, then it becomes very, very important to fill those very fundamental gaps. Because these fundamental principles have been or must be included in the framework, and that should be taken as a reference to the existing tools that have been developed by various governmental agencies. Global migration group has come out the idea of what we call, when we are talking of the 15 principles, then these 15 principles, my dear friends, includes non-discrimination, access to justice, protection of life and safety, governance of international borders, including non-refoulement, lawful returns, children in the context of migration, protection from violence, abuse, exploitation, human rights of all migrants, women, right to health, right to have decent work, right to liberty, adequate standards of living, right to education, disaggregated data, partnerships, and cooperation among the various governments. These are the fundamental principles which have been identified by the global migration group, and these groups must also backed by practical guidance. Suppose if we take into account one single principle out of these 15 principles, suppose protect the lives and safety of all migrants in transit and ensure rescue and immediate assistance to all migrants in distress. If this is going to be the principle of non-discrimination, then what should be the practical guidance? It means the practical guidance, my dear friends, should be to establish, operate, and maintain adequate, effective, and disability, age, and gender responsive rescue services at all international borders, including search and rescue at sea services in coastal states. Then only we can realize non-discrimination, if we apply this kind of a practical guidance. Another situation may also be there, another important dimension may also be there of the practical guidance. National governments must provide assistance without a discrimination and in a culturally appropriate manner to all migrants in large movements, including medical care, adequate food and water, blankets, clothing, sanitary items, and opportunity to rest. I mean the refuge and shelter. National governments, so far the practical guidance is concerned, further implement agreements with national protection bodies and other relevant actors to ensure timely and effective referrals for migrants in particular situations of vulnerability. And at the same time, national governments must put in place measures to respond to the special needs of children, whether they are traveling alone or with family, what we call, guardians or members. This should also be taken into consideration. So lot of what we call, if you apply all these, 15 principles, you will realize that there is a, adequate, mechanisms which has also been given practical guidance. We can further, contemplate, we can broaden the space, we can also what we call, operationalize whatever the, fundamental principles, how to implement. Similar kind of a situation is also applicable in case of the, SDGs, United Nations Sustainable Development Goals, which are popularly known as the UN Global Goals. And these goals must be implemented by 2030. So if we are taking a particular, goal, then we have to provide the practical guidance for their implementation, and that should be the part of the, entire trajectory of implementation, which is likely to be pursued by the national governments. Then only we can implement this framework for refugee protection. Now, I take you to another important, dimension, and that dimension is relating to, and which is popularly known as the Global Compacts on Refugees and Migrants. I'm sorry for the intervention. Thank you. It is, my dear friends, New York Declaration. 2016 New York Declaration, it has also, provided a turning point, a watershed point, an unprecedented vision. And let me begin my submissions on 2016 New York Declaration with a question. And the question is, what are the commitments which have been made under New York Declaration? My dear friends, New York Declaration contains bold commitments, unprecedented commitments. Unprecedented commitments in the sense of political character. Extraordinary measures have been, contemplated, both to address the issues we face now and to prepare the world for future challenges. When we are, talking of, commitments, or the word commitment has been prefixed with an adjective called bold. The bold commitments in the sense to protect the human rights of all refugees and migrants, regardless of their status, including the rights of women and girls, promoting their full, equal, and meaningful participation in finding solutions to their problems. To ensure, another important bold commitment, my dear friends, of ensuring that all refugee and migrant children are receiving education within a few months of their arrival in the new destination or in the countries of, reception. Another important bold commitment should be that has been, contemplated and envisioned in 2016 New York Declaration is to prevent and respond to sexual and gender-based violence, and to support those countries rescuing, receiving, and hosting large numbers of refugees and migrants. work towards ending the practice of detaining children for the purposes of determining their migration status, refugee status, asylum status. Another important bold commitment that has been advanced in the sense that in a very strong manner condemn xenophobia against refugees and migrants and support a global campaign to counter xenophobic and revanchist tendencies. It must also strengthen the positive contributions made by migrants to economy and social development in their host countries. And my dear friends, I am going to share another important contribution that has been made by a very, very important expert on international migration studies and international refugee law from Oxford University, who has contributed 3 or 4 days back a new book on refugees. I am talking of Mr. Alexander Betts from the University of Thoughts, Center for International Refugee Law and Migration Studies. He has sent me a link of this particular book, and I will also share that very link with all of you, where he is talking of that how refugees, as I have yesterday also I have pointed out that the refugees have also contributed in making and generating wealth or creating wealth in the host communities. So I will definitely share how the refugees themselves turn into assets in the hosting communities. Another bold statement and the bold commitment that has been envisioned in the New York Declaration is to improve the delivery of humanitarian and development assistance to those countries most affected, including through innovative multilateral financial solutions with the goal of closing all funding gaps, if there happens to be any kind of a gap. Further, another important bold commitment is to implement a comprehensive refugee response based on a new framework that sets out the responsibility of the member states, civil society partners, and the UN system. UN system, whenever there is a large movement of refugees on a protracted refugee situation, in those situations, the UN system must also be involved. Another important bold commitment under the NYD, New York Declaration, that is to find new homes for all refugees identified by UNHCR as needing resettlement and expand opportunities for refugees to relocate to other countries through, for example, labor mobility or education schemes. New York Declaration further contemplated as a bold commitment, or one of the bold commitments is to strengthen the global governance of migration by bringing the International Organization for Migration into the UN system. As of now, International Organization for Migration maintained its independent existence. Now it has been proposed in New York Declaration to bring this particular international system. It should be brought into the fold of UN system. Then if we take into account these bold commitments, then there is another important question, and the question is, what will happen next? It means, where from here? Because New York Declaration also contains concrete plans for how to build on these, commitments, bold commitments. It has basically, the New York Declaration contemplates further, my dear friends. New York Declaration contemplates to start negotiations leading to an international conference. And I will take you to these, global compacts. It contemplated, my dear friends, negotiations leading to an international conference and the adoption of a global compact for safe, orderly, and regular migration in 2018. The agreement to move towards this comprehensive framework is a momentous task. It means that migration, like other areas of international relations, will be guided by a set of common principles and approaches. And this is what we have, achieved in 2018. New York Declaration also contemplated to develop guidelines on the treatment of migrants in vulnerable situations. And these guidelines, my dear friends, will be particularly important for increasing number of unaccompanied children who happen to be on the move. New York Declaration further, intend to achieve and greatly achieved a more equitable sharing of the burden and responsibility for hosting and supporting the world's refugees by adopting a global compact on refugees in 2018. So it is axiomatic from these, measures that what has been intended by the New York Declaration was of a political nature. Up to 2016, the entire refugee situation was basically addressed by humanitarian considerations, by financial considerations, by sovereignty considerations, by internal security considerations, by nationalism considerations, by xenophobia considerations, by racial supremacist narratives considerations. But it was a very, very important realization in 2016, and particularly that was led by Obama administration in the United States of America, that the politicality or the political nature of this, humanitarian crisis was for the first time realized, and ultimately the community of nation states showed the greatest amount of maturity of a political nature, and they have, adopted, they have, culminated, concluded, and adopted New York Declaration in 2016. We have witnessed many paradigmatic shifts in 2016 when this particular declaration was adopted. Because this declaration has for the first time provided an opportunity to think beyond the box. Out of box, thinking ultimately prevailed over the legal minds, and it was the political, realization of international community. And that is why we are able that today 1951 UN Convention relating to the status of refugees has received only 148 or 146 ratifications. But if you see how many ratifications have been received by these global compacts, nearly 200 ratifications have been received, almost, or rather I should say, on the safer side, more than 180 ratifications. More than 180 ratifications. More than 180 ratifications. I'm emphasizing. It shows there is a reason why it has received this much of ratifications. Only because of non-binding character of these global compacts. Whereas 1951 UN Convention relating to the status of refugees is a hard law. It's a treaty law, and that is legally binding. So the paradigmatic shift that I was talking to, alluding to, is that for the first time in New York Declaration, my dear friends, it has been agreed upon that the refugees is not a burden. The refugee crisis is not a burden. Human migration is not a burden. Rather, it is a responsibility. It is a global responsibility, international responsibility. And therefore, burden sharing has been abandoned and the responsibility sharing principle has been preferred. So that is the beauty of New York Declaration. Though subsequently, even in 2017, in the month of December, another declaration has been there, which has also what you call approbated the mandate of the New York Declaration, and that too in a regional what you call perspective as well as international perspective, which is popularly known as the Baku Declaration. So number of steps have been taken, and these steps has basically crystallized international commitments in the most categorical manner. And therefore, today it is the responsibility sharing principle. It is the solidarity what we call principle with the refugee hosting countries. It has been realized if refugees are being hosted presently by a particular country like Bangladesh in South Asia, then the responsibility sharing is the international what you call commitment, and all the nation states supposed to come forward to assist and to ensure their solidarity with the refugee hosting country. And therefore 2016 New York Declaration and the global compacts on refugees have been what you call adopted to fulfill this particular mandate. And what we have received, two important: global compact on refugees and comprehensive refugee response framework, which is known as CRRF. Under one compact, two compacts are there: one on refugees, second one is on migrants. So refugee compact or compact on refugees, global compact on refugees contemplates two important what we call mechanisms. Now, if let me put a question: what does the global compact on refugees include? There is every possibility you may have this question in your end-term examination. And before I proceed further, it is very much important that I must deliberate what exactly are the ingredients of the global compact on refugees. My dear friends, global compact on refugees, or GCR has four important parts: an introduction setting out the background, guiding principles and objectives of the global compact. That is one important part. Second important part is comprehensive refugee response framework, CRRF, as it has been agreed by the member states in Annexure 1st of the New York Declaration of the 2016. I will share the copy of the New York Declaration. So CRRF has been contemplated. That is the second important part of the global compact on refugees. The third important part of the GCR is a program of action. A program of action that sets out concrete measures to help meet the objectives of the compact. And this program of action includes, my dear friends, arrangements to share burden and responsibilities through a global refugee forum. And it meets every 4 years. National and regional arrangements for specific situations, and tools like funding, partnerships, and data gathering, and the sharing of those, collections for the purposes of, evolving strategies, practices, and guidance. Another important function of this program of action is that it is going to work in areas in need of support, from reception and admission to meeting needs and supporting communities to solutions. And the fourth important part of the Global Compact on Refugees includes, my dear friends, arrangements for follow-up and review. Because that is the novelty of this particular, compact. I mean, both the compacts. Refugee compact contemplates, because the follow-up or post-implementation review has to be, there. And therefore, arrangements have also been, contemplated for the implementation of previous 3 important parts of the DCR. And under this particular arrangement, it includes, my dear friends, arrangements for the follow-up and review mechanisms, which will primarily be conducted through the Global Refugee Forum every 4 years, an annual high-level official meeting held every 2 years between forums, and the High Commissioner's annual report to the General Assembly. Follow-up and review will also include the development of indicators to measure success towards the achievement of the 4 objectives of the compact. It means the first three important objectives must also be assessed, measured to what extent the international community has been successful in implementing the 3 important arrangements, and that is, the guiding principles and objectives, program of action, and the CRRF, mechanisms. Because if you take into account, let me further elaborate, that is the, that is the comprehensive refugee response, framework. It is also having certain important, objectives, in the form of, components. Comprehensive refugee response framework, my dear friends, has certain important, components. Or rather, I should say, it is the most important and central component, arrangement or part of Global Compact on Refugees. Because the comprehensive refugee response framework contemplates a shared global responsibility principle. Key component, or one of the key component. Shared global responsibility, it means a specific acknowledgement that the protection of refugees and assistance to host states are a shared international responsibility. Another important, vision that has been contemplated under the CRRF is whole of society approach. Whole of society approach, within inverted commas. It means even stronger partnerships between host, governments, including line ministries, UN agencies, development, actors, private sectors, non-governmental organizations, financial institutions, civil society stakeholders, or the civil society organizations. They must, have a whole of society approach. It means all the stakeholders which are found in the civilized society, they must be integrated with this particular approach for the betterment of refugee protection, for the in the direction of achieving refugee protection. Another important dimension that comes to my mind is, and that has been contemplated as another important ingredients or component of GCR, that is relating to supporting host communities or host countries. It means providing host countries with additional and predictable humanitarian funding and development support. That is another important component of the CRRF. Then the fourth important component of the CRRF is well-funded emergency response. It means nation states have to pledge to meet the needs of refugees and host communities at the start of emergencies. Then there is another important component of, or key, one of the key components of the of CRRF is self-reliance, and that is commitments to include refugees in national development plans and invest in the future of refugees and local communities on equal footing. And the last one is last key component, though we may further supplement under these 6 important key components, and the last one happens to be enhancing durable solutions. It means we have to contemplate beyond the trajectory that has been provided in the name of durable solutions. What kind of a durable solutions we have been espousing for so long? Now the time has come to contemplate beyond this existing trajectory of durable solutions, and we should try to find out the fourth durable solution, the fifth durable solution, or sixth durable solutions, and so on and so forth. And therefore it becomes very, very important that we should commit to wider what we call avenues for refugees through resettlement and complementary pathways. It means the supplementary pathways, the complementary pathways must also be scheduled to sustain or to find the sustainable refugee solutions. Therefore, we have to learn certain important lessons. And that whatever the lessons have been learned from CRRF implementation demonstrate that 6 key elements are critical to comprehensive response. Now, we should review, my dear friends, some of the early results of these, because already more than 2 years have already passed ever since we have, adopted this, the Global Compact on Refugees and the Global Compact on Migrants. Suppose if you are going to have a review, let us have a review of the shared global responsibility principle under the CRRF. Ongoing dialogue, my dear friends, at regional level, that recently took place in Nairobi in Kenya, which is popularly known as the Nairobi Action Plan for Somali Refugees, where 8 governments are now working together on solutions for Somali refugees. It was made possible on the basis of one of the most fundamental principles of the international solidarity for refugee protection. So under this Nairobi Action Plan, under the CRRF mechanism of GCR, 8 national governments came together, and they have been working for the betterment, for the rehabilitation, for addressing the Somali refugees crisis. If you take into account another important dimension that is related to the comprehensive regional protection and solutions framework in Central America, also reflects responsibility sharing principles building on existing regional policies and action plans. It is also working. Then this is something which is happening at the regional level. But when we talk of at the global level, my dear friends, at the global level, The GCR text makes provisions for a global refugee forum. And under this particular program, which is known as the Global Refugee Forum, where concrete pledges and contributions towards international cooperation on forced displacement will set into motion, that has also started what we call assuming a viable what we call place in the space designated for refugee protection. So this is how we have been, CRRF under GCR has started functioning. Another important dimension, particularly the 6 important key components, where I was just submitted that we should think beyond the existing trajectory of durable solutions. So we have to enhance durable solutions philosophy, because it will build on initial work in expanding global resettlement, global reintegration spaces, resettlement spaces, including the emergency resettlement countries joint support mechanism, where countries like Chile and Croatia are building their resettlement capacity with support from experienced resettlement contexts, as we have been witnessing in Sweden. It will also build on the Canadian originated global refugee sponsorship initiative. This initiative has been started by the government of Canada that supports groups interested in offering private sponsorships to increase resettlement or complementary pathway options for refugees. This is how we can what we call further enhance the idea of durable solutions beyond existing idea of durable solutions. And personally speaking, my dear friends, I really like this particular understanding that has been initiated by the government of Canada. Even the refugees, for the protection of refugees, the institution of voluntarism has been further strengthened. This institution of voluntarism has been incorporated under the CRR mechanisms as enhancing durable solutions philosophy. Under this kind of mechanisms, individual families or an individual family as an institution come forward, and they generally or a family may offer that it is willing to host a particular refugee family or a refugee individual and provide their sponsorship at their own expenses. So I address this particular mechanism as voluntarism, though it has been taken as a global refugee sponsorship initiative by the government of Canada. But for the first time, my dear friends, this particular mechanism was started evolving when for the first time in the month of March 2011, the first batch of Syrian refugees embarked upon a Mediterranean journey, and for the first time they knocked the doors of government of Hungary at the border. Then instead of offering or getting any kind of assistance from the governmental agencies in Hungary, it was the people of the border villages in Hungary who came out with all kinds of support for Syrian refugees on a voluntary basis. And this is how for the first time the voluntariness of refugee help that has been what we call subsequently institutionalized, and this is how the institution of voluntarism came into existence. Another important initiative, another important what we call mechanism that has been contemplated as a bold commitment in the 2016 New York Declaration is supporting host countries, which is known as the solidarity. international solidarity or the global solidarity with the refugee hosting countries. Under this kind of a mechanism, providing additional and predictable development support during the CRRF period has resulted in almost what we call 6 billion US dollars in development assistance for refugee hosting context up to 2020. Countries like Cameroon, Republic of Congo, Ethiopia, Niger, Pakistan, Uganda, and many other refugee hosting countries, particularly Chad, have been receiving from international development agencies these agencies have established refugee and host community funding agencies, and for the betterment and resettlement of refugees, and a new window of funding has also been created by the World Bank as part of the increased what we call support. So supporting host countries has also attracted, my dear friends, a lot of infrastructural, logistical wherewithal, and this has resulted again because of the New York Declaration, because of the Global Compact of the 2018, because the well-funded emergency response has to be what we call attended, and that has resulted in a series of quick win projects for migration countries, or the countries who are hosting refugees, and particularly which have been what we call designed by the UNHCR, and particularly designated as such by the UNHCR for 2018, 19, and 2020 to maintain momentum with comprehensive plans and dovetail with longer term 3 years in national plans of the preparing governments, and supporting and ensuring the solidarity of the international community at the institutional what we call level. This is how the GCR has been functioning, and particularly the second important key component of the GCR, that is the refugee comprehensive response framework. Because the treaty that established the League of Nations, my dear friends, in 1920, the organization that preceded the United Nations, contained no general provisions dealing with human rights. But it was the Charter of the United Nations organizations, and that too adopted after the atrocities of the World War II, that took, my dear friends, a very, very decisive steps towards international protection of human rights. Therefore, if you go through, as again I am simply invoking and refreshing your memory, if you go to the preamble of the Charter of the United Nations organizations, you will find that the United Nations or the UN Charter affirms faith in fundamental human rights, in the dignity and the worth of the human person, in the equal rights of men and women, and of nations large and small, and he speaks in the form of what we call of determination to promote social progress, better standards of life, fundamental human freedoms, particularly Article 1, Subclause 3 of the UN Charter becomes relevant for the purposes to promote and encourage respect for human rights and for fundamental human freedoms for all without any kind of a distinction, and whatever may be the grounds of discrimination, those grounds must not be taken into consideration. Rather, equal treatment should be meted out to whosoever is available on this beautiful planet. And therefore, there are certain important articles. These articles must also be reflected in the comprehensive refugee response framework. I mean the Articles 13 subclause 1b, Article 55 subclause C, Article 62 subclause 2, again Article 76 subclause C of UN Charter. These articles must also be the part of any kind of functioning when we are implementing GCR, and particularly the second important arrangement, which is popularly known as CRRF. Because as per Article 56 and Article 55C, which we have deliberated in previous semester, and these two important articles read in conjunction with United Nations member states have a legal obligation. Legal obligation to take joint and separate action in cooperation with UNO for the achievement of universal respect and observance of human rights and fundamental freedoms, without any kind of a distinction, without any kind of a distinction as to the race, the religion, language, sex, or any other important considerations. I'm not able to reproduce the exact what we call synchronization of the grounds which have been adumbrated under these articles, but this is the gist of these two important articles, Article 56 and Article 55 subclause C. Therefore, idea of promulgating an international bill of rights was developed immediately after the adoption of the UN Charter, and ultimately led to the adoption of the Universal Declaration of Human Rights in 1948, and subsequently two important covenants have also been adopted in 1966, which subsequently made operational, came into existence or made operationalized in the year 1976. So if we undertake these three important instruments, then these three instruments, my dear friends, has ultimately implemented a global idea of human rights. And when we are talking of the protection of refugees, then the protection of refugees under the GCR must also contemplate, and contemplates in reality, the application of International Bill of Human Rights. GCR is nothing, or in other words, let me put it like this: the implementation of 2016 New York Declaration and whatever the mandates of a non-binding character have been achieved under New York Declaration of the 2016 must be backed by International Bill of Human Rights. Then it does not mean we are not taking into consideration 1951 UN Convention relating to the status of refugees. No, that is also there. But it is a note of caution that has been provided to the national governments. Not only the note of caution, but it is the concrete or the concretization of commitments, bold commitments, which have been agreed upon in New York Declaration. And the government of India is also party to New York Declaration, my dear friends, if you take into account. But nobody is talking of this, since it happens to be a soft law. It is a non-binding one. But sometimes, my dear friends, there is nothing called non-binding when there is a question of human right is involved. Everything becomes binding when there is a question of what we call of human rights. Because I am of the view, if national governments are taking this kind of a plea, that they are not in a position to implement their human rights obligations under international law, then the national governments are under an obligation under their constitutions to implement human rights. Because if the national governments are reluctant to extend any kind of a protection to refugees, then it should be the part of their legislation. National governments are basically playing some kind of a hide and seek kind of game. As per their political expediencies, as per their political conveniences, they have been what you call arguing, recalibrating, reformulating, and reconceiving refugee protection. Because the refugee protection has become volatile, uncertain, amorphous, and vacuous what you call orientation in each and everywhere whenever we are talking of the national commitments. So we have to have a determinate what we call province of refugee protection within the national architecture or within the national legal mechanism. If the national governments are reluctant to extend any kind of a national protection to refugees, they must have the capacity, they must have the political audacity, and they must officially, they must issue statements that we are not going to extend any support to refugees. At least nation states must understand that a particular geopolitical entity is reluctant to provide any kind of an assistance to refugees. And accordingly, even the constitutions must also be amended. That we are ready to provide protection only to our citizens. Adequate amendments should be made. It will give some kind of a stability in terms of judicial interpretations, in terms of administrative orientations, in terms of what we call of legal understandings. We are going to stabilize our understandings. Because ever since the inauguration of the constitutions, all the constitutions in South Asia, we have been receiving different interpretations of some of the constitutional provisions. So international solidarity has not been invoked. International responsibility sharing principle has not been invoked, despite the fact government of India has been extended all kinds of help to the government of Bangladesh with regard to the protection of refugees, particularly assistance to refugees, Rohingya refugees in Bangladesh. Same is the situation in Pakistan. Afghan refugees have become a political contention. Despite the fact the government of Pakistan is having a bilateral agreement of 1993 between Afghanistan and Pakistan for the repatriation program of Afghan refugees in Pakistan back to their country of origin, that is Afghanistan. But majority of the Afghan refugees are still reluctant to go back to their country of origin in Pakistan. Similar circumstances have been, there or they are still there in Iran, where Afghan refugees are reluctant to return to their country of origin, and particularly the Shia Afghan refugees. Because on the basis of their, sectarian identity, they are being discriminated in Afghanistan. So in such a scenario, my dear friends, what is important is that we must, as a part of South Asia, as a part of the SAARC grouping, we must evolve a regional mechanisms for the protection of refugees, as we have been witnessing in Latin America, in Central African and Central African states, particularly in case of Somali refugees, in case of other refugees, and some understandings have also been there for the protection of the Palestinian refugees. Though the Palestinian refugees have been abandoned by the international community, they are not getting any kind of support, and they are becoming day by day invisible. So for refugees in South Asia, we should also what we call create a comprehensive response, refugee response framework, and we should also evolve a mechanism under GCR, that is the Global Compact on Refugees, for the protection of refugees. I will continue. Any questions?
So I had few questions. I wrote it in the chat box. Can you see it once?
Yeah, please. Oh, I'm sorry. Today I have forgotten to see. Let me attend. Yes. How does, as per Miss Anupa Aryalji, she is asking a question, my dear friend. So, how does Global Compact interact with the Refugee Convention? Does it add to the norm of Refugee Convention or supplements it? Very interesting question. Miss Anupa ji, in 2021, let me divide entire refugee protection at a global level into two broad categorizations. And after these categorizations, you would be in a better position to understand the importance of each and every instrument. Refugee protection has got two wisdoms: Geneva based wisdom and New York based wisdom. When I am using the word Geneva based wisdom, I am primarily talking of 1951 UN Convention relating to the status of refugees. Where we find a humanitarian character of refugee crisis, where we find a human rights character of refugee crisis or refugee problem. And this Geneva based wisdom was not considered sufficient to protect each and every aspect of the refugee problem or to address each and every aspect of the refugee crisis. Therefore, refugee protection is a movement. Refugee protection is not an sporadic movement. It is not an intermittent movement. It is not an intersectional movement. It is a perennial peregrination of human mind to protect a refugee or to address refugee issues. And therefore, what has been started as a post-Second World War scenario for the protection of refugees, at different stages of its evolution and graduation to this day, different aspects have been identified of the refugee issues. And some of the important aspects have been attained the status of just cause. Some of the important ingredients of the refugee protection mechanisms have attained larger than life, what we call, understandings. So the Geneva based wisdom has been further supplemented by the New York based wisdom, which we find in the form of New York Declaration of the 2016. Earlier in 1951, I am not starting my arguments from the Treaty of Westphalia, Miss Anupa, where I have, divided. If you go through the very first and second, slides of my, submissions, you will find. Then when contention for internationalization of refugee problem, when internationalization generally, took place, that was the year 1967 when the additional protocol was adopted. So I am not taking those, important goalposts and timelines, but I have, simply making a presentation on the basis of the two important arguments. And it is also axiomatic from your question that the New York-based wisdom has basically supplemented, complemented, and try to, complete what has been thought by the international judicial legal minds in 1951. Now we have added the political mind as well. So this is the, most important, shift. And now it has been further supplemented. So we should try to understand that the New York Declaration is a complementarity. Because in 1951, Refugee Convention, there are certain principles. The principle of, non-refoulement under Article 33, subclause 1. So in no way we can underestimate the efficacy, relevance, and contemporaneousness of 1951 convention. If you take my initial arguments of today, what I have, submitted, that we can even find out avenues for protecting refugees outside the mandate of 1951 convention. 1951 convention, over the years, as per the estimation of some of the, best scholars, more than half a dozen scholars of international refugee law have contended, ma'am, that 1951 convention is attaining the status of jus cogens. And therefore, that humanitarian wisdom got supplemented with the political wisdom. And whatever the fundamental principles for the global refugee problem, which have been identified in 1951 in the form of this convention, Refugee Convention of 1951, have been recalibrated, refined, and further improved upon by the 2016 New York Declaration on Refugees and Migrants. So we find a complementarity, an element of complementarity, an element of the common pathway, an element of supplementarity, an element of the subsidiarity. So it should not be taken in isolation. That is one, submission. Again, the second important aspect of your question is relating to how is comprehensive refugee response framework different from the current refugee response approach. The basic and the most fundamental difference between the existing approach and the new one that has been, given in the CRRF. Approaches were volatile. Existing approaches were volatile. Some of the approaches have been designated as human rights-based approach to refugee protection. Some of the human rights-based approaches got certain intersectionalities of the political character, like sovereignty-driven approaches, national security-driven approaches, xenophobia-driven approaches, resource-driven approaches. These kinds of and many other important, approaches. But we find a jungle of, approaches so far the existing approaches are concerned. We find indeterminacy of approaches, volatility of approaches, but the contribution of comprehensive refugee response framework has been or is, ma'am, that it has institutionalized, systematized, organized the idea of refugee protection, where we find after the implementation, after the application of comprehensive refugee response framework mechanism, we have been witnessing the institutionalization of international responsibility framework, international solidarity framework for refugee hosting countries. We have been witnessing allocation of resources at international level for the refugee protection. That ensures further accountability, good governance of migration and refugee protection. That also ensures transparency in refugee affairs. And for the first time, the dignity of refugees have also been or going to be respected and have been respected. And we have also witnessed the operationalization of CRRF mechanisms at regional level, or in other words, we may put it like this, as regionalization of CRRF mechanism. So this is how it is different from the existing approaches. It ensures a better what we call commitment, because it also ensures when we are talking as a fourth what we call stage, what we have been witnessing, because there are four important parts, and the fourth part of GCR happens to be the follow of action and review. That follow of action and review ensures transparency, accountability, as well as international commitments, whatever the bold commitments have been agreed upon in 2016 New York Declaration. Any other question, or would you like to offer something new, ma'am?
No, sir. Thank you so much.
You're welcome, ma'am. You're welcome. So thank you very much, guys and dolls, for your very apt participation in today's deliberations. I am immensely thankful to all of you. Thanks a lot. Thank you very much.
Thank you.
Thank you.
By tomorrow, I will, whatever remains to be sent to you. So previous what we call slides, as well as up to today, whatever we have deliberated, I will share all the documents, readings, relevant readings, additional readings, research readings, and very few readings from examination point of view. So thank you very much.
Thank you, sir.
You're welcome. You're welcome, ma'am. Thanks a lot.
Thank you, sir.
You're welcome, Sultan Sahib. Thanks a lot. Bye-bye. Take care.